Welcome, everybody. Kathleen Zellner has replied a response to motion for remand, and it's a 56-page document. So, Jeff, take us away.
Okay, sit back and relax because I think this is going to be a long one. State of Wisconsin versus Stephen A. Avery, case number 05CF381. Honorable Judge Angela Fatass Flowers presiding. Defendant appellant's reply to the state's response to motion to stay appeal and remand. The defendant appellant, Stephen Avery, Mr. Avery, by his undersigned attorneys, Kathleen T. Zellner and Stephen G. Richards, for his reply to the state's response in opposition to his motion to stay the appeal and remand the cause to the circuit court states as follows. Introduction. It is a supreme irony that in one of the most blatant examples of a wrongful conviction, the state's only response is to falsely accuse Mr. Avery's lead counsel of nefarious conduct for discovering a sixth Brady violation. Rather than seeking justice, the state wants to slay the messenger by putting forth more false allegations, a skill that it has mastered over the last 16 years. The state turns a blind eye towards its past actions of withholding exculpatory evidence. When the state disclosed a CD of violent porn from the Dassey Yonda computer 12 years after the CD was created and concealed from prior counsel, the state argued, as it does now, that Mr. Avery was attempting to add new material to his 97406 motion. When the state facilitated the destruction of 2011 evidence and had agreed to allow Mr. Avery to test, the state argued, as it does now, that Mr. Avery was attempting to add new material to his 97406 motion. The court did not accept those disingenuous responses then. It should reject the same disingenuous responses now. The state asked this court to overlook the fact that in further violation of discovery, it failed to disclose to Mr. Avery's prior counsel that a former driver who delivered newspapers to the Avery salvage yard in November 2005 observed two men, including a shirtless Bobby Dassey, the state's primary witness in securing Mr. Avery's conviction, pushing Miss Hallbach's Route 4 down the Avery Road prior to its later discovery on the Avery property. Discovery in quotation marks. Discovery. In its response, the state, and she quotes, "It is reasonable to conclude at this point that Mr. Avery is not pursuing these claims in good faith." Close quotes. However, the state's conclusion is clearly rebutted by the procedural history of this case, the veracity of Mr. Sawinski's statements, the supporting affidavits, and the state's history of misconduct. While the state has not been prejudiced in any way by its own misconduct in this court's prior rules granting Mr. Avery's motions to remand, its response merely mimics its previous responses to Mr. Avery's motions, arguing that Mr. Avery is dragging this appeal out and that he should voluntarily dismiss his pending appeal. It is the state's pattern of concealing and withholding exculpatory evidence that has forced Mr. Avery to delay his appeal numerous times already, delaying his quest for a new trial and eventual freedom. The argument. That's pretty powerful stuff, I'd say, right there, Beverly, wouldn't you? Yeah.
Yeah.
Argument number one. The state's argument that Avery did not conduct a reasonable investigation before filing his motion is completely meritless. The state argues that Avery's counsel violated Wisconsin Statute 802.05 by not conducting any affirmative investigation into the assertions made by Mr. Sawinski in his affidavit before filing the motion for remand. Without citing any precedent or acknowledging Mr. Avery's prior discovery requests, the state suggests that Avery was required to attempt to open a new records request to verify Mr. Sawinski's call and or ascertain the identity of the female officer with whom Mr. Sawinski spoke prior to filing the motion. State's response, and she cites where it is. Citing Bellick versus, Sismasmik, the state maintains that Avery's counsel may not rely simply on the word of a person like Sawinski before presenting Mr. Sawinski's affidavit to the court. The state's argument should be rejected because it is based on a false premise, i.e. that Mr. Avery's attorney did not conduct a reasonable investigation into into Mr. Sawinski, and that the averments in his affidavit before filing the motion for the remand. The state's argument appears to be based off its self-serving conclusion that Mr. Avery's counsel stumbled upon Mr. Sawinski and within 24 hours filed the pending motion to stay the appeal and remand for Mr. Avery to file a supplemental post-conviction motion with the circuit court. The state's conclusion is demonstrably false and the result of a careless, sloppy reading of Mr. Avery's motion. The simple truth is that Mr. Avery's counsel conducted a thorough investigation relative to Mr. Sawinski. Certainly, a great deal more effort was made to vet Mr. Sawinski than the state made to vet its primary witness, Bobby, who has been caught in numerous untruths. Go ahead, Myron.
I absolutely love that she put that in there.
Yeah. During Mr. Avery's trial, Bobby testified that he was asleep and woke up around 2:30 p.m. and looked out of the kitchen window of the Dassey Yonder residence, and that he saw Miss Halbach's RAV4 pull up, Miss Halbach exit the vehicle, and start taking pictures of the Dassey Yonder van. When Miss Halbach finished photographing the van, Bobby claimed to see her walking up towards Uncle Steve's trailer. Bobby testified that he took a shower, and when he left the property at about 2:45 to go bow hunting, claimed that Miss Halbach's RAV4 was still in the property, but he did not see her. Bobby's testimony was the only evidence presented by the state that the RAV4 never left the Avery property after October 31st, 2005. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Miss Halbach never left the Avery property. Based upon Bobby's testimony, the state claimed that Mr. Avery was the last person to see Miss Halbach alive. However, Bobby's testimony is replete with lies, contradicted by numerous witnesses, including his own brother Brian, who told law enforcement that Bobby saw Miss Halbach leave the Avery property on October 31st, 2005. The CD, which the state withheld from Mr. Avery's counsel, also establishes a timeline of internet searches directly contradicting Bobby's trial testimony that on October 31st, he was asleep from 6:30 a.m. to 2:30 p.m. And there's a footnote down at the bottom, and I'm going to jump to that footnote. Mr. Avery's expert determined that the internet on the Dassey Yonder computer was accessed on October 31st, 2005, when only Bobby was home at 6:05 a.m., 6:28 a.m., 6:31 a.m., 7 a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. So jumping back to where the footnote is. Additionally, Bobby's testimony that his back was scratched by his puppy has been refuted by Mr. Avery's expert, Larry Blum, MD. You know that? Unlike the state's failure to investigate the credibility of its primary witness, Bobby, Mr. Avery's counsel rigorously investigated Mr. Sawinski's claims. Mr. Sawinski first emailed Mr. Avery's counsel law firm on December 26, 2020, and Mr. Avery's counsel and her investigator vetted the legitimacy and veracity of the information provided by Mr. Sawinski over the next 3.5 months before filing the pending motion to stay. Prior to filing the motion, so just check on that date, Millbilly, December 26, 2020 would have been after the original brief was filed, right? So this came in sort of when that brief was in process, and now she feels like she's got enough information to, being that it's the fourth month, 4/22, it's almost 4 months later. So she did a 4-month investigation. So prior to filing the motion, Mr. Avery's counsel did the following things. One, reviewed Mr. Sawinski's email sent on December 26, 2020, and we're going to read in one of the appendices that Zellner herself has submitted an affidavit regarding this email. Item 2, conducted an extensive background check, producing, among other information, Mr. Sawinski's previous address, phone numbers, job history, social media accounts, car purchases, criminal history, relatives, etc. And that would be in a second affidavit that Zellner's going to find, or maybe a different paragraph of the Zellner affidavit. Number 3, reviewed all of the discovery produced by the state prior to Mr. Avery's 2007 trial, searching for any record of Mr. Sawinski's phone call to the Manitowoc County Sheriff's Office.
Now,
Number 4,
there is no audio trail of that based on what Buting asked them to give him, in my opinion.
Yeah, so it's not. Yeah. So number 4, searched and corroborated Mr. Sawinski's statements based on other evidence, including but not limited to the affidavits of Blaine Dassey and Kevin Ramlow in the Zellner affidavit. 5, hired an additional licensed investigator, James R. Kirby, who we'll refer to as Investigator Kirby, to conduct an additional background check of Mr. Sawinski through additional databases. In addition to her affidavit, she'll have something to say in an affidavit from Investigator Kirby. 6, after confirming the veracity of Mr. Sawinski by its extensive investigation, Mr. Avery's counsel and staff conducted a telephone interview with Mr. Sawinski on April 9th, 2021, related to what he claimed to witness. The affidavit of our last slide. If you haven't seen that, go back and look at it. Number 7, after this interview, Mr. Avery's counsel and staff prepared an affidavit and requested Investigator Kirby to meet with Mr. Sawinski in person and conduct a second interview of him to determine his credibility. After thoroughly interviewing Mr. Sawinski and reviewing his affidavit with him for any changes, Mr. Sawinski executed his affidavit on April 10th, 2021. And we're going to see that in the Zellner affidavit and the Kirby affidavit. And those affidavits are both attached as Group Exhibit A. Based on the foregoing, the notion that Mr. Avery's counsel did not reasonably investigate Mr. Sawinski and the information he has provided is simply untrue. Undersigned counsel and her investigator have had the opportunity to assess Mr. Sawinski's credibility based on his demeanor and the consistency between his observations and other known facts related to the disappearance of Teresa Hallbach. Undersigned counsel's investigation into Mr. Sawinski and his affidavit have continued since the filing of the motion to remand, the results of which to date have only confirmed the credibility of the information he provided. And she has footnote 3. I'm going to jump down to footnote 3. Also, contrary to the state's false claim, which Mr. Sawinski's affidavit states quite clearly, Mr. Sawinski did not receive any reward, nor did he seek to receive any award. Probably that should be reward. See Group A, and we're going to see, I think, a text message that Sawinski sent Zellner. But jumping back up, the state's reasonable investigation, in quotations, argument, which reasonably can be construed as an attempt to unreasonably divert this court's attention from the materiality of the information provided by Mr. Sawinski, is based on a misleading characterization of Wisconsin Statute 802.05. Its response suggests that an attorney must detail the steps Mr. Avery's counsel took to verify the truthfulness of the assertions made in the pleading itself. Wisconsin Statute 802.5 imposes no such obligation. I think Travis said that. On the contrary, requiring an attorney to disclose such information would infringe upon the worked product privilege. She cites an example of Dudek versus Circuit Court from Milwaukee. She quotes from that, most materials, information, mental impressions, and strategies collected and adopted by a lawyer after retainer and preparation of litigation and relevant to the possible issues must be initially classified as a work product of the lawyer, not subject to inspection or discovery, unless good causes for discovery good cause for discovery is shown. So she's kind of nailing them there. That no, I don't have to show you my stuff. It's a privilege. The state's argument that Mr. Avery's counsel did not reasonably investigate Mr. Sawinski and the statements in his affidavit because a new open records request was not made is not only unsupported by precedent, but it is illogical. Based on the information in Mr. Sawinski's affidavit, the state was constitutionally required to disclose Mr. Sawinski's phone call and the information he provided to law enforcement to the defense before Mr. Avery's trial. Undersigned counsel has reviewed all of the discovery disclosed by the prosecution, including the records of phone calls made to the Manitowoc County Sheriff's Office, and nowhere in the discovery does such a record exist of Mr. Sawinski's phone calls. The state provides no explanation as to why a record of Mr. Sawinski's call would be produced in response to an open records request now, if evidence of the call was withheld in the first instance. Indeed, the non-disclosure or concealment of exculpatory information is the crux of a Brady violation. The state seems unaware that Manitowoc County Sheriff's Department disclosed in 2018 that it no longer had the telephone calls from citizens to its non-emergency number.
Now,
Yeah,
side
well,
note,
who just said that?
there's 3 dispatch lines, the 4200, 4201, and 4202. There's 79 dispatch calls for the whole, from November 3rd to November 12th, and it's 30 on one line and 49 on the other. And we don't have no record at all for the 4200 number, which was placed in the paper and on the news. Multiple
So,
papers.
and the other ones weren't, so you'd expect the bulk of the tips to come in through that line, right? And that's
Think
just
that.
happens to be the one we don't have. Unbelievable. Okay. That, so she cites at the end of that paragraph that we're going to see all that in the Zellner affidavit. Lastly, the state's efforts to compare the situation to Bellick is a complete non-starter. In Bellick, the plaintiff alleged that the defendant, whom she had hired to replace windows in her home, stole $60,000 in cash from her office. And she cites the case, Bellick, on pages 422 and 423. However, the homeowner was present when the defendant removed the window from her home and admitted that she did not observe any unusual bulge in the defendant's clothing to suggest that he had secreted away such a large amount of cash. It was also undisputed that although the plaintiff discovered the money missing 3 days after the windows were replaced, she did not report the cash missing to either her husband or the sheriff for another month. The sheriff's office investigated the complaint and closed the investigation without referring the defendant for criminal prosecution. The circuit court granted summary judgment in favor of the defendant and further found that the lawsuit was frivolous, awarding attorney's fees and costs to the defendant. In affirming the circuit court's award of sanctions under Wisconsin Statute 802.05, this court noted that the plaintiff's attorney did not conduct any pre-filing investigation or post-filing discovery to confirm his client's allegations. This court also observed that a number of circumstances about the plaintiff's allegations, including the unlikelihood that she would leave so much money unattended in the presence of a stranger, the improbability of the defendant being able to walk out of the residence with $3,020 bills on his person, and the plaintiff's delay in reporting the cash as missing did not pass the smell test, which should have triggered additional investigation by her attorney. This court held that given these warning bells, the plaintiff's attorney's failure to conduct any investigation beyond taking his own client's word for what occurred violated Statute 802.05. It is readily apparent why Bellick is inapplicable. Unlike the plaintiff in Bellick, as set forth herein, undersigned counsel had conducted a thorough investigation of the allegations in the motion for remand. However, the undersigned counsel is not relying on her client's rendition of the events to support the allegations in the motion. Instead, she is relying on the assertions of an independent third party who has no stake in this litigation. Most importantly, unlike Bellick, the state has not identified any undisputed evidence that sounds like warning bells, calling into question the veracity of Mr. Sawinski's averments. In short, Bellick has no bearing on any issue presented by Mr. Avery's motion for remand. Likewise, it is readily apparent that the state has not shown the motion for remand to be based on frivolous allegations and or that the motion was filed in violation of Statute 802.05. Okay, reason number 2. Because the state disputes Mr. Thomas Sawinski's credibility, this cause must be remanded. In its response, the state is quick to cast judgment on Mr. Avery's new witness and the information that he provided without producing any evidence and or arguing that any evidence rebuts anything attested to by Mr. Sawinski. However, besides Mr. Avery's counsel's verification of Mr. Sawinski's background and information he provided, the record itself supports the veracity of Mr. Sawinski's affidavit and corroborates his statements. Among other evidence discovered by Mr. Avery's counsel, Mr. Sawinski's affidavit is consistent with Kevin Ramlow's affidavit that he spotted the RAV4 on Highway 147 east of Avery Salvage Yard on November 3rd and 4th. You'll see the affidavit of Kevin Ramlow attached as Exhibit B, and we'll be reading that later. Additionally, Mr. Sawinski's affidavit is consistent with the affidavit of Bobby Dassey's own brother, Blaine Dassey, in which he attested that he saw Bobby in possession of and driving a bluish-green vehicle Blaine did not recognize from the Avery property onto Highway 147 around 3:30 to 4:30 on October 31st. Blaine was on the bus. I will read that again. The day that Teresa Hallbach disappeared. See the affidavit of Blaine Dassey attached as Exhibit C. All this aside, the state's criticism of the veracity of Mr. Sawinski's statements is inappropriate for this court to consider anyway. And how many times have we heard that from Travis, that the appellate court is not a fact-finding court? It is not for this court, but rather the circuit court, sitting as the trier of fact, to weigh the evidence presented at trial. That's Langley County versus Latow. Also see Wisconsin Statute 805.117. And she quotes, "Due regard shall be given to the opportunity of the trial judge, of the trial court to judge the credibility of the witness." And that's according to Bottomley versus Stevenson. So she's almost saying that the circuit court doesn't even really have an option to attempt to weigh the facts here. According to this Bottomley versus Stevenson, the state's response merely substantiates that a conflict concerning Mr. Sawinski's credibility demands the circuit court's intervention for a credibility determination. Number 3, Mr. Avery's motion is proper. As the state's response acknowledges, the decision to remand is left to this court's discretion. In its response, the state makes unfounded accusations of Mr. Avery's counsel's trying to delay Mr. Avery's appeal, because we all know Stephen wants to spend more time in jail. The state should be reminded that this court previously granted 3 of the 4 motions Mr. Avery filed to remand and supplement his post-conviction motion. These were ordered on September 8th, 2016, July 11th, 2018, and February 27th, 2019, attached as Exhibit D. Like Mr. Avery's current motion, none of these were considered frivolous nor filed for an improper purpose, as the state now argues. Therefore, the state's convoluted argument that Mr. Avery somehow does not have a right to file a motion to stay his repeal and remand his case does not have any merit. Pursuant to Wisconsin Statute 97406, all grounds for relief available to a person must be raised in his or her original, supplemental, or amended motion. Mr. Sawinski's affidavit supports Mr. Avery's claim that the state has engaged in a pattern of withholding exculpatory and/or impeaching evidence from the defense. In addressing a Brady claim, a court is required to assess the cumulative impact of all the suppressed evidence to determine its materiality. This according to a case called Kiles v. Whitney. Mr. Avery submits that this court's reasoning in its February 27, 2019 remand order that, and she quotes, "Due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than positioning the claims to be procedurally barred in a future proceeding," close quote. And that should apply here. Mr. Avery has brought this issue to the court's attention in a timely manner. That the information Mr. Sawinski provided was not discovered and investigated by Mr. Avery's counsel until after the briefs were submitted in this appeal should not affect this court's decision whether to remand Mr. Avery's case. Mr. Avery does not want to waive this issue by not addressing it at this time. The appeal must be stayed, and this issue must be remanded to the circuit court for proceedings that should include a hearing concerning the undisclosed phone call Mr. Sawinski made to the Manitowoc County Sheriff's Office. The undisclosed phone call and information Mr. Sawinski provided to the Manitowoc County Sheriff's Office is exculpatory and/or impeaching evidence which contradicts the state's primary witness, Bobby Dassey's testimony, and inculpates Bobby Dassey as a third-party suspect pursuant to Denny. The state cannot credibly argue that Mr. Sawinski did not contact Manitowoc County Sheriff's Office with information related to seeing Bobby and an unidentified man pushing the RAV4 before the RAV4 was discovered on the Avery property on November 5th, 2005. The state's actions demand that further proceedings be conducted to determine if Mr. Avery's due process rights have been violated under Brady. For the reasons above, this court should allow Mr. Avery's appeal to be stayed and remanded to the circuit court for further proceedings to determine whether Avery can supplement his motion to support his claim that the state violated his constitutional rights under Brady. Conclusion. Wherefore, the undersigned counsel respectfully requests that this court enter an order staying this appeal and remanding the cause to the circuit court to permit Mr. Avery to pursue a supplemental post-conviction motion in connection with Mr. Avery's discovery of previously suppressed evidence by the state, dated this 22nd day of April 2021. Respectfully submitted, Kathleen Zellner. Okay, the next, and we'll move on to certificate of service. And this is just lawyerly stuff. I certify that on April 22nd, 2021, a true and correct copy of defendant appellant's reply brief to the state's response to Mr. Avery's motion to stay, appeal, and remand for the cause of Mr. Avery to supplement his post-conviction motion with new witness. Nobody cares about this. And then she moves on to her own affidavit. But do you want? Is there any comments that you want to make, Millbilly, before we move on to her affidavit, or do you want to save them until the end?
Save them to the end.
Okay, sounds good. Okay, so now what we're going to read is her own affidavit, and as you know, when we went through, she said, "I did my due diligence, and I'm going to report on my due diligence in my affidavit." So this is her own affidavit. It's got several points to it. It starts off: State of Wisconsin versus Stephen A. Avery.
But I just had a thought. What if Chuck calling Stephen to go look at lights was to draw him away from his trailer or garage or that area for a specific reason?
And what reason might that be?
I don't know. I can only speculate.
He's admiring space right now.
I've been on the Chuck and Earl bandwagon for a long time.
I've given up on predicting who's guilty in this case. I just know who's innocent. This is the affidavit. Affidavit. What's that, Justin?
I said amen to that.
Amen to that. The affidavit of Kathleen T. Zellner. Now comes your affiant, Kathleen T. Zellner, and under oath hereby states as follows. Number one, your affiant is of legal majority and can truthfully and completely testify to the matters contained herein based on my personal knowledge. The factual statements herein are true and correct to the best of your affiant's knowledge, information, and belief. Your affiant is of sound mind and is not taking any medication, nor has your affiant ingested any alcohol that would impair your affiant's memory of the facts as stated in this affidavit, which is not always true when I read these things, but it's true today too. Your affiant is the lead counsel for Stephen Avery in case number 05CF381. Your affiant states that on December 26, 2020, at 10:42 p.m., her law offices received an email from an individual by the name of Thomas D. Sawinski. Mr. Sawinski's email is attached and incorporated herein as Exhibit 1. We'll get to that. Your affiant reviewed the email carefully and decided to conduct a thorough background investigation of Mr. Sawinski before contacting him. Your affiant reviewed all materials related to the Avery case, including all prior discovery requests, witness affidavits, and interviews to determine if Mr. Sawinski could be determined to be a credible witness. Item 6. Your affiant also reviewed all discovery requests that she had made since assuming the representation of Mr. Avery in 2016. Specifically, your affiant made the following request would be to Manitowoc. Please provide a copy of the dispatcher log related to Manitowoc County Sheriff's Office, case number blah, 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 and or any document/log that exists related to communications between the Manitowoc County Sheriff's Office dispatch and law enforcement, as well as with any private citizens. So your phone records, basically.
Yeah, we have the dispatch log, we have the audio, and yeah.
Yeah.
It doesn't.
We haven't.
It doesn't make sense. I'm just saying.
Yeah. You have a comment, Meyer?
Yeah, but we only have those logs for 2 out of the 3 numbers, don't we?
I don't know which number it is.
Yeah. And also, I mean, I still think that depending upon who's the police phone log was serviced by a carrier. Nobody's asked the carrier whether or not they could provide a list of people who called into that number. They might still be able to do that.
Big pass.
If you listen to the Calumet audio, all of it, they're actually updating their 911 system during majority of the 10th, 11th, and 12th. So it's a lot of that. A lot of the operator calling, doing tests. It was gruesome to go through, but yeah.
Redundant and painful to listen to.
Like
Mr. Larry, oh, go ahead, Mari. Sorry.
I said, it's painful to listen to, like most of this case.
Yeah. Mr. Larry Levine, a deputy inspector at the Manitowoc County Sheriff's Office, responded, "We do not have recordings from that time period." And she puts that in bold quotes. And she says, emphasis added, which means she added that. Your affiant realized that any phone call from Mr. Sawinski to the Manitowoc County Sheriff's Office has been destroyed. This request and the response are attached and incorporated herein as Group Exhibit 2, and that would be the response of Levine. Okay, number 7. Your affiant's law firm conducted an investigation of Mr. Sawinski, which included gathering information about the following: his date of birth, relatives, employment history, telephone numbers, email addresses, possible criminal record, possible civil record, and car ownership. Number 8. Your affiant's law firm confirmed that Mr. Sawinski had worked at the Manitowoc Herald-Times during the relevant time period. Financial documents dating 2005 to 2006, as well as newspaper articles from 2005 to 2006, listing Mr. Sawinski as a paper carrier of the Manitowoc Herald-Times, are attached and incorporated here too as Group Exhibit 3. Number 9. Your affiant's law firm confirmed that Mr. Sawinski emailed the Innocence Project on January 7th, 2016. That's Laura Nyrider's group, right? Regarding his witness observations. Attached and incorporated herein as Exhibit 4 is a copy of the relevant email. Your affiant confirmed that Mr. Dean Strang, Mr. Avery's prior attorney, did not have an email from Thomas D. Sawinski, but he could not confirm whether Mr. Buting had received an email because when Mr. Buting switched email servers, some of his prior emails were inadvertently deleted. Number 10. On April 1st, 2021, a request was made to your affiant's investigators, Edward R. Kirby and Associates, that a further investigation be done of Thomas D. Sawinski as delineated in the affidavit of James R. Kirby. So you can see we're piling up on stuff to read, which is why this is 50-something pages. Number 11. On April 9th, 2021, your affiant's law firm conducted an interview of Mr. Sawinski by telephone and prepared an affidavit reflecting that interview. Mr. Sawinski was visiting relatives in Manitowoc County. Oh, that's how come it happened in Manitowoc. I was confused because later on I'm going to find out he lives in Denver now. That's why he went to Manitowoc to do it. On April 10th, 2021, James R. Kirby drove to Manitowoc County to interview Mr. Sawinski and review the accuracy of his affidavit, which was based on his telephone interview conducted by your affiant's law firm. Mr. Sawinski executed the affidavit, which was notarized by Mr. Kirby. Mr. Sawinski's affidavit is attached and incorporated herein as Exhibit 5. Number 13. On April 12, 2021, your affiant's law firm filed defendant appellant's motion to stay appeal and remand the cause for Mr. Avery to supplement his post-conviction motion with a new witness affidavit establishing a Brady violation and a third-party Denny suspect. Mr. Sawinski confirmed on April 21st, 2021, with your affiant that he did not know of any reward money being offered and that if money were given to him, he would donate it to the Halbach family. That's good.
Wow.
Mr. Sawinski's text message is attached and incorporated here too as Exhibit 6. Number 15, your affiant and her law firm hold the opinion that Mr. Sawinski is a credible witness based upon the extensive investigation your affiant conducted as described above and in the affidavit of James R. Kirby, who she said she was going to list as Investigator Kirby and didn't call him Investigator Kirby once in 15 items. Further affiant saith not, Kathleen T. Zellner, blah, 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 notary public. Moving on. Okay, so this next thing we're going to read, and it's going to be a lot easier to follow on the YouTube. If you're listening to this podcast on the drive home, just check onto the YouTube, and you'll be able to see this is a mail. And this mail was the one that Mr. Sawinski sent to Stephen Avery Lawyers at gmail.com. So I guess this would be the one to Dean and Jerry, I'm guessing. Just finished second season. So, okay, let me see. Let me start. So Thomas Sawinski, and it says his email address. I'm sure that email is going to blow up.
This
Thanks
would
to
be
the-
the one that KZ got.
Yeah, Stephen
Oh,
Avery.
this is what KZ got. Okay, yeah. So this is. Oh, that's right. Because of the date on it. That's right. Thank
Yep.
you, Justin. Yeah, the date's December 26, 2020. And now his emails, because we know that Millbilly has millions of viewers from around the world, so there's no doubt that this email is going to blow up. tquest87@yahoo.com. To Stephen Avery Lawyers at gmail.com. Just finished the second season. I lived there at the time. I was a motor route driver that was on the property every day to deliver newspapers. A few days before they found the RAV, let's see, he has a few grammatical errors here. A few days before they found the RAV, I was delivery papers at about 1 to 2 a.m. So this is the first time we've heard the time. And saw Bobby Dassey and another old man pushing the RAV down the road towards the junkyard. No lights at all. I almost hit them. They were very spooked. As you know, it's a dead-end street. After delivery paper, I had to go right back past them. Dassey stood in the road next to the RAV trying to stop me from getting by. As I approached, my headlights were on them 100%. The other guy hid behind open passenger door that was open from pushing the vehicle. I didn't slow down. I drove in the ditch to get by, waving as I said, "Paperboy, gotta go." It's a good thing he didn't have it. I was on a bicycle. You know that movie, I Want My $2? Dassey had no shirt on, and the other guy had a very scraggly beard and seemed to be in his 60s. I did call police, and they said they would contact me. They never did. That's different than saying we already know who did it. After season 1, I emailed an attorney of Stevens and no response. I've decided to reach out one more time as this information seems vital, especially after what I just watched. I live in Denver now, but I lived in Manitowoc, which is spelled very badly wrong, for over 20 years. Sent from Yahoo Mail for iPhone. Oh, so he put it on his phone. That's kind of a good excuse to do bad typing. And so the next exhibit looks like it is a request from Zellner to Manitowoc, asking for the phone calls that we were talking about, and Millbilly has said extensively that he would love to listen to, but they don't have. Please provide a copy of the dispatcher log related to Manitowoc County Sheriff's Office, case 2005-000-8844, and or any document /log that exists related to communications between Manitowoc County Sheriff's Office dispatch and law enforcement, as well as with any private citizens. And that's Zellner's request to MTSO. And then she gets a reply, and this is the email she got back from Larry Ledvina.
Many people have got this email.
Yeah. I hope he's doing it on cut and paste, because he has to type it out every time. That's just a waste of taxpayer dollars. I have received your request for recordings of calls from November 3rd, 2005. And again, this the thing about this November 3rd date, it's probably worth it to point it out now. It's different from I think it's different from what it says on the affidavit. I thought on the affidavit they said it was
6 calls for that day. 24-hour period, they had 6 people call dispatch.
On the 3rd, but I think the affidavit that Zellner submitted says it's the 5th of November.
I'm just saying, for the whole 24-hour period, only 6 people called dispatch that day, and nobody called on the 4th.
They're denying her date, but they're denying her the wrong date. She specifically requested for the 5th. They're saying, "Oh, well."
The 3rd, but they actually have the 3rd. That's a good point. We do not have recordings from that time period. Maybe they're Remaker's personal possession. You should ask Remaker. Jacob. For any document requests, be specific on what documents and cases you are requesting. Thank you. And that's from Larry Ledvina, the Deputy Inspector for Manitowoc County Sheriff's Office. and it gives the address. And if you're thinking about, if you see the address and thinking you want to go there, think again and go somewhere else. The next page is a newspaper article, and this is some of the research she.
Was that
Go ahead,
just,
Mary.
what was that underneath it? You scrolled a little bit past it. Did she respond to the email? What is that below it?
No. This I think is like an email footer.
Oh, it's
Which is this message is intended for the use of the person or organization to whom it is addressed. So I think it's just a standard footer
right.
to that. But yeah, keep me honest because I'll try and skip over stuff because I just can't wait to be done.
I don't blame you.
So this next thing is a newspaper article which is thanking the carriers, and it's really just listing them all by name. But I'll just read so you can see all the pictures sort of as a border around the article, and you can see some of these people are actually, quite young, like this guy, Brian Wisnick on the bottom left. I mean, he doesn't look like he's more than 12 years old. It's about the age that a lot of people have paper routes. Imagine Sawinski at the time could have been as young as 17 years old if he was driving a car, right?
Imagine contacting some of those people who are listed in that newspaper and asking what time they delivered newspapers.
Yeah.
That's the job for Zellner.
Oh, I know that, but
yeah. So just the title of this is The Rest of the Newspaper Carrier Force. And if you can see it on the YouTube, Billy has taken the time to underline it. And this is literally a list of names. Here's a list of the remaining members of the newspaper carrier force who aren't listed in those pictures. And Billy has underlined the name of Thomas Sawinski in that orangish kind of font. If you could scroll down a little bit, there you go. Right there. So I'm not going to bother reading all these names just because it'll be a thing. And there's also a coupon to Cosmic Bowling. I'm not sure that coupon is still valid because this article is from October 15, 2006. But go for it. You know what I mean? Cosmic Bowling. It's all the fun you can have in one night. Next is another article, which is from October 15, 2005. So it looks like annually, since the previous one was from October 15, 2006, this one is from October 15, 2005, which is, again, exactly 1 year earlier, not even almost. Thank you to all the Herald Times reporters and Lakeshore Chronicle carriers. And again, Millbilly has underlined Thomas Sawinski. Ivy Sawinski, that could be his sister, his mother. And what's this other one you have a question mark next to, Millbilly?
is that Chase?
Yeah, the Chase name just makes me wonder.
And wonder about what?
Well, Carla Chase,
Stacy Chase.
Dassey Chase.
Dassey Chase,
Are they
yes.
related? And then we got another one right here. Herman.
Oh, boy. Yeah. Cleveland Auto Salvage.
A lot of these names are familiar with me.
Yeah.
Kind of like.
Well, it seems like there's only so many names in that whole place. Like everybody's got the same name, and they're all like German names. So next, I think the next thing is the case summary, and I don't necessarily think that there's anything. It's the Pacer log. I think it is just a search. It's just current Chapter 7. Trustee, Milwaukee, one debtor. I think this is a search of the financial records of Sawinski.
Yeah, we can skip over that. We don't need to look at his.
Yeah.
His financial records. We're going past that.
Yep. Here's another email.
Okay, so this starts on Thursday, January 2016. So I actually have to increase the font size on my computer, or I'm gonna have to put on glasses and look like a guru.
But this is the one sent to the Innocence Project.
Awesome. Okay. And that was sent on January 7, 2016 at 1:43 p.m. Hello, my name is Thomas Sawinski, and I delivered newspapers to the Avery residents every day for years. I delivered papers at the time of the Hallbach situation. Somewhere between October 31st and November 5th, 2005, not sure which day, I turned down Avery Road to delivery their paper when I almost ran into two people pushing a dark-colored small SUV down the road with absolutely no lights on. It was dark, and I delivered the papers as soon as possible each day so I could get home in time to get my son ready for school and drop him off. So he's probably not 17, or maybe he is, I don't know, but probably a little bit older than I had originally suspected. As I passed them, as I passed them, I realized I had stumbled onto something that seemed out of place. I spooked both of them tremendously. I drove down the dead-end road and put the paper in the tube and turned around to come back down the road. I knew I was in a shady situation, so I approached them with a good amount of speed to get around them fast. As I approached, the guy pushing from the driver's side stopped and tried to stop me in the middle of the road. I went half in the ditch and just waved to calm the men into thinking that I was oblivious to what was going on. I didn't see who the man was on the passenger side, but the young man, maybe 18 or so, that tried to stop me was not Brendan Dassey. His build was thin and fit and about 5'9". Days later, after seeing footage on TV of the RAV4 being found on the property, it clicked that it was probably the SUV that I had seen that night. I called police and notified them. They didn't seem interested at all and said thanks for the info. Never asked me to fill out a report or even asked me my name or phone number. At the time, I just figured they had enough evidence and were not concerned with my information. After seeing the documentary on Netflix, I decided that someone other than Manitowoc County officials needs to hear this at HERE. They were pushing in the direction towards the house from the driveway. I feel obligated to share this. From the highway. Thank you. I feel obligated to share this now that I know some of the circumstances involving the way Manitowoc handled the case. And this is sent from my T-Mobile 4G LTE device. And he's moved up in the world. There's a couple of things about that affidavit or that email, right, that he sent back in 2016. One, he wasn't. It doesn't seem like he was sure of the day, right? He was sure. He seemed much sure now, and I wonder how much that sureness has to do with the fact that we know that it wasn't even on the news that she was missing until the 3rd. So that's really when the search happened, and it was discovered on the 5th, and he knew it was before it was discovered on the 5th. That doesn't leave too many days, right there. So I can see how that memory was clarified, but it's a little disturbing that he said that his story is a little bit different. I'll have to say that. Moving on, it looks like the next thing is is this the Kevin Ramlow one? This next one is a repeat of the Sawinski affidavit. So let's read it again, and we can see the difference between that and the email. Number 1, I am of legal majority and can truthfully and competently testify to the matters contained herein based on my personal knowledge. The factual statements herein are true and correct to the best of my knowledge, information, and belief. I am of sound mind and am not taking any medication nor have ingested any alcohol that would impair my memory of the facts stated in this affidavit. I resided in Manitowoc, Wisconsin for over 20 years. We now know he lives in Denver, but that doesn't say, I guess that's really not germane. In 2005, I was employed as a motor route driver at Gannett Newspapers, Inc. and delivered papers in and around Avery Salvage Yard. While delivering papers, I drove my personal car, which was a tannish gold 4-door sedan. Maybe it was an AMC Pacer, for all we know, right? I cannot recall the make and model of the car at this time. On Saturday, November 5th, 2005, I was, and again, right, that's a astounding recollection of the date, different from a few days before the RAV was found. On Saturday, November 5th, 2005, I was delivering papers on the Avery Salvage Yard in the early morning hours before sunrise. I drove down Highway 147 and turned left onto Avery Road. Soon after I turned onto Avery Road, I witnessed an individual who I later realized was Bobby Dassey and another unidentified older male pushing a dark blue RAV4 down Avery Road on the right side towards the junkyard. Bobby was shirtless, even though it was early November. The second man appeared to be in his 50s or early 60s. had a long gray beard, and was wearing a worn, puffy jacket. Had a larger frame and was around 6 feet in height. The RAV4 did not have its lights on. Attached and incorporated herein as Exhibit A are photographs marked where I saw the RAV4. I drove down Avery Road towards the mailboxes, left the Herald Times in the mailbox, and turned back around. I felt very afraid as I approached the two individuals because Bobby Dassey attempted to step in front of my car, blocking my exit. I was within 5 feet of Bobby Dassey, and my headlights were on the entire time. The older man ducked down behind the open passenger door. I swerved to the right and drove into the shallow ditch to avoid hitting Bobby Dassey. I called out, "Paper boy, gotta go," because I was afraid for my safety. Bobby Dassey looked me in the eye, and I could tell with a look in his eyes that he was not happy to see me there. I knew that Bobby Dassey and the older individual were doing something creepy. Number 6, after I learned that Teresa Hallback's car was found on November 5, 2005, I contacted the Manitowoc County Sheriff's Office and spoke to a female officer. I reported everything I stated in this affidavit to the officer. The officer said, "We already know who did it." I provided my phone number, and they said they would contact me soon. I never heard back from the police. Item 7. After watching season 1 of Making a Murderer, I contacted Avery's trial attorneys to inform them of what I saw. I never heard back. Nothing has been promised or given to me in exchange for this affidavit. Further saith not Thomas Sawinski, City of Manitowoc. We know he signed it in Manitowoc even though he lived in Denver because he was visiting relatives. Notarized by James Kirby, who's Zellner's investigator. Okay, moving down. Oh, there's the picture. You annotated that picture, Milville. You want to explain that?
Yeah, well, the X that she marked on her exhibit, I circled it, and then where the mailboxes were located, I circled that too.
Cool. Okay, so moving on, and so can you put your cursor on that picture that you have? Where is the RAV found? So people can see that.
Over here.
Yeah, up there. Cool. And Stephen's house is over by that loop-de-loop. Over. A lot of people aren't familiar with the geography.
Is over here. This is Barb's. We got Dolores, Chuck, outbuildings. This is the way they say the RAV came in, but now we're saying it came in this way. So.
Yeah. Awesome. Okay. And I think next, what's appended here is it looks like a text message, although it looks like a portable network graphic. It looks like somebody took a screenshot of their phone because it's sort of in the format of a text message, and it reads as follows. And I assume this is the Kathleen Zellner from Sawinski. I just wanted to let you know that I never heard of any 100K reward until after this just all recently came out.
Well, he wouldn't have, because he doesn't live in Manitowoc, and the billboards were mainly put up in the Manitowoc area and Two Rivers. And unless he's following this case like us, like everybody here in the chat, I highly doubt it.
Yeah. And a lot of people have seen, on Reddit, in the cesspool that is Reddit, a lot of people think that the 100K is for any information leading to Stephen's exoneration. That's not the case.
So it's leading to the arrest and conviction of the real perpetrator.
A real perpetrator, that's right. So he continues in this email. Of course, the money is nice, but this was never about a reward. I never knew of a reward, and if the 100K ever happens to get released to me, I would like it all donated to the Hallback family. ! I don't like my integrity being questioned. Feel free to make this public. Thomas Sawinski. So that's just a text. It's not an affidavit. But that's, I think the guy's pretty serious if he says something like that. Next is the affidavit of Kirby, who's Zellner's investigator, and is going to talk about the due diligence he did in investigating Sawinski. So that reads, State of Wisconsin plaintiff versus Stephen A. Avery defendant, case number, Judge Flowers presiding, affidavit of James R. Kirby. Now comes your affiant, James R. Kirby, and under oath hereby states as follows. Your affiant is of legal majority and can truthfully and competently testify to matters contained herein based upon my personal knowledge. The factual statements herein are true and correct to the best of my knowledge, information, and belief. Your affiant is of sound mind and is not taking any medication, nor has your affiant ingested any alcohol that would impair your affiant's or facts stated in this affidavit. Number 2, your affiant is the president of Edward R. Kirby and Associates Incorporated, a professional investigators firm located in Elmhurst, Illinois. Your affiant is a licensed private investigator and have been licensed since 1988. Your affiant is currently licensed in Illinois, Indiana, and Wisconsin. Number 3, your affiant undertook an investigation in the above captioned case starting on April 1st, 2021, at the request of the law firm of Kathleen T. Zellner and Associates. Number 4, Ms. Zellner requested that your affiant conduct a background check on an individual named Thomas D. Sawinski, which included a current residential address and a contact information. Additionally, your affiant ran Thomas D. Sawinski's name through a Wisconsin court access database and similar data source for the state of Colorado. Ms. Zellner indicated that her office had already conducted a background check on Mr. Sawinski, but she was looking for additional information. Number 5, after your affiant completed those tasks, Ms. Zellner requested that your affiant attempt to contact Mr. Sawinski. Your affiant made repeated phone calls to Mr. Sawinski's cell phone, however, his voicemail had not been set up, and your affiant was unable to reach him. Number 6, your affiant had a local investigator from Denver, Colorado deliver a letter prepared by Ms. Zellner to the witness on April 7th, 2021, requesting that he contact her office directly. Number 7, your affiant was notified by Ms. Zellner's office that they had made telephone contact with Mr. Sawinski on April 8th, 2021, and that he was visiting his family in Manitowoc and was willing to speak to Mrs. Zellner directly. It is your affiant's understanding that Ms. Zellner and her staff interviewed Mr. Sawinski on April 9th, 2021, and prepared an affidavit from that interview. Number 8, Ms. Zellner requested that your affiant do an in-person interview of Mr. Sawinski on April 10th, 2021, and review the affidavit that had been prepared as a result of Mr. Sawinski's interview and with Ms. Zellner and her staff. Number 9, your affiant drove to Manitowoc on April 10th and met with Mr. Sawinski, who reviewed the affidavit and felt confident that the encounter occurred on a Saturday because his normal routine was to deliver papers very early on Saturdays. It was very startling to Mr. Sawinski to see someone on Avery Road that early in the morning. That's good. At least he's making an excuse as to why he has a recollection that it's on Saturday. Number 10, your affiant has interviewed over 10,000 individuals throughout the course of his career. In reviewing the affidavit with Mr. Sawinski, your affiant found him to be credible because of his demeanor, and his affidavit was supported in part by the investigation that your affiant did of Mr. Sawinski. Furthermore, Mr. Sawinski's story is supported by information that your affiant had obtained from his investigation and from other witnesses regarding Bobby Dassey and the vehicle. Number 11, from speaking to Mr. Sawinski, your affiant observed that Mr. Sawinski displayed no knowledge or expectation of a reward during your affiant's interview with him. Number 12, currently your affiant is investigating Mr. Sawinski's description of a second individual that he observed with Bobby Dassey as detailed in Mr. Sawinski's affidavit. Further saith not James R. Kirby, and that was notarized by Elizabeth Boringa. Okay, and then next we have the affidavit of Kevin Ramlow, and that's relevant, as was stated above, because Kevin Ramlow testifies, or in his affidavit, swears that he saw the RAV on the turnaround on State Highway 147. As I'm reading this, Millbilly, maybe you want to show that picture and show about where that is on the turnaround. So, affidavit of Kevin Ramlow. Now comes your affiant, Kevin Ramlow, and under oath hereby states as follows. Number 1, I am of legal majority and can truthfully and competently testify to the matters contained herein based upon my personal knowledge. The factual statements herein are true and correct to the best of my knowledge, information, and belief. I am of sound mind and I am not taking any medication, nor have I ingested any alcohol that would impair my memory of the facts stated in this affidavit. That's our common boilerplate affidavit thing. Number 2, in 2005, I lived near Mishicot, Wisconsin. I'm familiar with the Tadich family because I'm acquaintance with Sean Tadich. Sean's brother Scott is now married to Stephen Avery's sister Barb. On November 3rd and 4th, 2005, when I was in Mishicot, I saw Teresa Halbach's vehicle by the East Twin River Dam in Mishicot at the turnabout. At East Twin River Dam in Mishicot at the turnabout the bridge. Okay, as I drove by on West Highway 147. I think there's some grammatical errors there, but all right. So I'm going to hold. You want me to keep on reading? Or you want me to hold? Around midday, November 4th, 2005, I stopped at the Cenex gas station at the intersection of Highway 147 and State Street in Mishicot. While there, I saw and read a missing person poster for Teresa Halbach. I remember that the poster had a picture of Teresa Halbach and written description of Teresa Halbach in the car she was driving. I recognized the poster attached as Exhibit A to this affidavit as a copy of the one I saw at the Cenex station in 2005. I saw that you had it. Do you want to show it now? Did you show it? No, where the RAV was. I thought I saw the map come up. Okay. I recognized that the written description of the vehicle on the poster matched the car I saw at the turnabout by the dam. While I was in the Cenex station, a Manitowoc County Sheriff's Department officer came into the station. I immediately told the officer that I had seen a car that matched the description of the car in Teresa Halbach's missing person poster at the turnabout by the dam. Excuse me. Item 7. In December 2016, I watched Making a Murderer. In this series, I recognized the officer who I talked to at the Cenex station on November 4, 2005. A photograph of this officer is attached as Exhibit B to this affidavit. Having watched Making a Murderer, I now know that his name is Andrew Coburn. Item 8. After I watched Making a Murderer, I sent a text message to Scott Tadich. Having reviewed a saved copy of that message, I know that I sent it on December 12, 2016 at 6:13 p.m. In the message, I told Scott Tadich that I had seen Teresa Halbach's car in Mishicot on November 4, 2005, and had told the officer in the Cenex station. On December 19, 2016, I sent Scott Tadich another message. I never heard back from Scott Tadich. Copies of the text messages conversation I had with Scott are attached as Exhibit C to this affidavit. Number 9, nothing has been promised or given to me in exchange for this affidavit. Signed Kevin Ramlow, notarized by some notary public whose name I can't read. Okay, the next is the missing person poster for Teresa Marie Halbach. I think we've all seen that, and we all know that she Kelly Cowell's favorite dark green RAV4, right? It's in black and white, but
Yeah.
I think everybody's seen that one. So moving down, we see everybody's favorite picture of Andrew Coburn. I think that's probably the one that he has on his Facebook page of himself. What do you think, Billy?
Mm-hmm.
Yeah.
That's my favorite shit look that I've ever seen during the entire documentary.
And actually, this picture is kind of famous because it's one of the complaints of his Netflix his Netflix suit is that they show him making that face as they're reading back the issue about the calling in of the RAV4 license plate. And his claim is that he didn't make this face during that time, and that this was taken from another time and sort of superimposed at that time, and therefore the documentary was, sort of what's the right word? Sort of surreptitiously edited or
Misleading.
Misleading, yeah, exactly. So, and I guess to some extent I can't blame him, but he's a public figure after all. So this is the text. This guy saving text from 2016. So this is him to Scott Tadich. I just watched the series Making of a Murderer, and I got to tell you, I need to get in touch with one of their lawyers. As Coburn, I saw Art Cenex and told him that the vehicle was at the old dam on a Thursday or Friday, and I'm guessing November 3rd was the day he called the plates in. And on December 12th, remember that first one was on December 12th at 1813. This is at 1841. Hey, give me a call at my phone number. And Scott texts back, okay, I will, but I'm really sick now. And can I? It says can, but I assume it's followed by can I do it later or something like that. And he never got back to him. All right. So again, Zellner attaches more. And this is the affidavit of Blaine Dassey, which is relevant because you'll recall in the original filing, she says, well, Blaine claims that he saw Bobby driving the RAV4. Now, she's kind of relitigating the case, which she's really only supposed to be talking about the Sawinski affidavit, but I guess this is how potentially, reason that Bobby might have got his hands on the RAV in the first place. Blaine says he saw him in a strange car. State of Wisconsin versus Avery, affidavit of Blaine Dassey. Now comes your affiant Blaine Dassey under oath and hereby states as follows. 1, I am of legal majority. Is that even true? Yeah. I am of legal majority and can truthfully. We'll find out how old he was when he signed this.
He was 17 in 2005. This is when he signed this in 2017.
Oh, okay.
This is why Queso opened up their investigation again.
Well,
because of this affidavit.
Because of everything that Zellner had brought forth.
The opening statement is standard for a lot of things. It's even standard if you were to do a civil union. They ask that of the people in the civil union as well to make sure that they're sound mind and they haven't taken any medication or drank any alcohol and that they're able to make that decision. I mean, it is a roundabout question when it comes to any legal document, just so that the person can state that, or they can say, the person stated they were of sound mind when they signed this.
Yeah. I was questioning back at the time, Blaine was, you remember for the youngest one on the stand. I mean, he was probably in high school, but he looked 12. So I was wondering if he was actually old enough, But yeah, this was 2017 clearly, and he hasn't been drinking and taking any drugs or anything like that. Right. Item 2, in October 2005, I lived with my mother and brothers at 129308 Avery Road, Two Rivers, Wisconsin, 54241. My brothers' names are Brendan, Bryant, and Bobby Dassey. Brendan and I shared a bedroom. Bobby had his own bedroom. Brian kept some clothes at the house but lived with his girlfriend and was rarely at the residence. Tom Yonda had moved out of the residence in early 2005.
October 15th.
Item 3. When none of us were home, the residence was always locked. And someone else said something different recently. I don't want to say who. Item 4. My Uncle Stephen Avery, Uncle Stephen, only came to the residence when my mother and his sister Barb was home. I never remember my Uncle Stephen entering the residence when my mom was not home. Item 5. I remember that my Uncle Stephen had cut his finger 1 to 2 weeks before October 31st, 2005. Item 6. I remember on October 31st, 2005, seeing my Uncle Stephen carry a white plastic bag to his burn barrel. I did not see a fire in the burn barrel. However, the police pressured me into saying there was a fire in the burn barrel and visible smoke was coming from the burn barrel. My testimony about the fire and smoke coming from the burn barrel was not true.
If you read, I went over the December filing, and they state that Brendan Dassey attested to seeing items in the burn barrel as he walked to Stephen's trailer. It's a bunch of baloney.
Yeah. Kelly could have got him to say anything, right? Well, Kelly probably threw that in there. Item 7. I remember on October 31st, 2005, seeing a bonfire behind my Uncle Stephen's garage that was about 3 feet high. That hardly qualifies as a bonfire in my book, but okay. The police tried to pressure me into saying that the flames of the bonfire were much higher. So at trial, I testified that the flames on the bonfire were 4 to 5 feet high, but that testimony was not true. Police put the height of the flames in my head, and I agreed to it. That's in quotation marks. Yeah, well, we have the Christmas. That's right. We have the Christmas phone call, right? And in the Christmas phone call, Stephen talks to Scott Tadich about how big the fire was when he and Barb got back from the hospital, and they agree that it was about the size of a coffee table. and it was burnt, and it was at the point where it was nearly burnt out. So that's remembering from from. Yeah. And Bloodhound Fabian, who was able to smell the burning plastic, somehow wasn't able to smell a complete corpse being disposed of in a quote unquote bonfire the size of a coffee table.
Well, duh.
So,
didn't that plastic smell stronger than dead burning flesh?
Yeah, you make a good point.
That was
Item 8.
sorry.
Yeah, no, yeah, we're full of that here on the Bill Bullet channel. On October 31st, 2005, I was with Brendan up until I left to go trick-or-treating. I distinctly remember Brendan wanted to use the computer at slightly before 5 p.m. because I wanted to make a phone call, and his use of the dial-up internet computer would have prevented me from doing that. I know that Brendan was not at Uncle Steven's trailer up until I left to go trick-or-treating. So what he's basically saying is this Brendan brought the mail over as a bunch of crap. I think we all know that anyway, because Ma brings the mail every day. So there would have been no mail to be had. Yep. Item 9. There was only one computer at the residence, and it was always in Bobby's room, sitting near a desk, even though somebody else said differently.
But the video shows that's accurate.
That's right. That's the one that Henberry got when they released the property. Number 10, the computer had a password. Number 11, the computer had an America Online dial-up internet connection. Number 12, Bobby was the primary user of the computer. Number 13, at no time did I ever do searches for pornographic images or words related to pornography, words related to violence, words related to death, words related to mutilations, words related to torture, words related to guns or knives, words related to Teresa Halbach, words related to Stephen Avery, words related to DNA, or words related to dead, mutilated, or dismembered female bodies. Item 14. At no time did I ever create a folder for Teresa Halbach, my Uncle Stephen, DNA, or news stories on the murder. Number 15. Item 15. The only time I used the computer was to do my homework and occasionally send instant messages. Number 16. Item 16. I remember my mother Barb hiring someone to reformat the computer, but I'm not sure who that person was. Item 17.
Side note, Blaine, Brendan call. I've listened to a few of them, not very many, but Brendan asked Blaine about PlayStation, and he says no. When Brian moved out, he took it, so I've mostly been on the computer now. And this is after March, so.
Yeah. Item 17. I do not have any personal knowledge of who made the appointment with AutoTrader to have my mother's van photographed, but I did help clean the van so that it could be sold. Item 18. At the time, my family had 2 burn barrels located behind our house.
Now, here we go.
I think that's 4.
4, 3, 2. Which one is it?
Yeah. I know. I got to tell you that my kids are around Blaine's age, and I'm not sure they can tell you what color my dumpster is either. So taking out the trash is something that's somehow anathema to anyone between 12 and 21. Number 19. I was familiar with the gravel pits to the south of the Avery salvage yard, but I did not go to the gravel pits.
Bobby
who
Dassey.
was it?
Bobby Dassey claims he doesn't know anything about that. He don't even know where Cuss Road is.
Well, he didn't know what it was called, Cuss Road. I did not go to the gravel pits to hunt. I stopped hunting when I was 22. Item 20, on October 31st, 2005, when the school bus driver brought Brendan and me home, we traveled west on State Highway 147. I saw Bobby on State Highway 147 in a bluish or greenish vehicle heading towards Michigan. Bobby was not driving his black Blazer. Bobby was not home the rest of the evening while I was home. Attached and incorporated herein as Exhibit A is a map of the location of Bobby's vehicle that I described in this paragraph.
And when,
Further saith
when they interviewed Brian Dassey on the 9th, he don't recall who was home. He can't remember. He tells Wendy Baldwin and Lisa Wilson that.
Yeah, I mean that's the Ma Avery approach, right? I know what I've seen on TV and I don't remember nothing else. So you want to put this map in context, Billy, with the one that we were showing before? Just kind of tilted a different way, right?
So this is 147. This is Avery Road. Ma's house would be over here. Stevens would be this way. Jambo Creek is somewhere up here. So this is before they got to Jambo Creek. The bus is got Blaine and Brennan on it. And they get home about, what, 3:45?
But also before the bridge, right?
Way before the bridge. Way before the bridge.
So he could drive again over by the bridge at this moment.
But why are they pushing it?
Yeah.
But at that point, maybe he left in a hurry and, like, before it drained the battery.
Okay, so if anybody has any questions on that map, put it in the chat. I think the turnaround is just way up in the direction of that map, right?
It's east. This is north.
Yeah.
That's east.
The top of the page, I meant by up, right? It's way above the top of the page.
Yeah, this is nowhere
Yeah.
near the turnaround.
Yeah.
This is right after, shortly after they turned off of Avery Road.
That's right there by the house of the gentleman who was interviewed that we just covered on the last.
Sawinski. So the bus is coming the same way as Sawinski came because they had to take they would take a left on the Avery Road.
No, I was more talking about the gentleman who was about the Herald Times at the time it came.
Yeah. Oh yeah. Yeah. His name was CW.
Spring tubes.
Spring
Spring
tube.
Tube. Yeah. Okay. Okay. And the next thing is a note from the Court of Appeals, and this must be the orders of the court. Zellner had mentioned that the court had made several remandings, and I'm not sure this one contains all of them, but this one contains at least one of them, and we'll see exactly what the court ordered as we finish this one. This is orders from the Wisconsin Court of Appeals. It gives the address, and it's the various attorneys and judges. To Angela Sukowitz, to Lynn Zigmund, to Tricia Bushnell, to Tom Fallon, to Doug Johnson, to Jeffrey Castle, to Stephen Richards, right, Mr. Butt Dial guy. You are hereby notified that the court has entered the following order. I need to make it bigger because I can't read it. Okay, Stephen Avery, by counsel, moves the court to stay this appeal pending a disposition of the motion filed in the Circuit Court on August 26, 2016, seeking post-conviction scientific testing of evidence. The state does not object to the stay request and suggests the remanding record to the Circuit Court pursuant to Wisconsin Statute 808.075 for the court's use in determining the pending motion and any subsequent motion based upon the results of further testing, if any is authorized by the Circuit Court. A stay of this appeal and remand of the record are appropriate. Avery also moves the court to substitute attorney Stephen G. Richards for attorney Tricia J. Bushnell as local sponsoring counsel. The motion is granted. On January 22nd, 2016, order explained the obligations of sponsoring counsel. Successor sponsoring counsel Stephen G. Richards must sign every document filed in this court. Upon foregoing reasons, it is ordered that this appeal is stayed pending further order of this court. It is further ordered that within 20 days after the date of the Circuit Court enters an order disposing of the motion filed in the Circuit Court on August 26th, Stephen Avery shall inform the clerk of this court whether 1, Wisconsin Statute 808.75 applies to this appeal, 2, whether briefing may commence, or 3, whether there will be additional Circuit Court proceedings related to the matter of the August 26th motion. It is further ordered that the record on appeal is remanded to the Circuit Court for the court's use in determining the pending motion and any subsequent motion for further testing, if any, is authorized by the Circuit Court. as per Wisconsin Statute 808.075. It is further ordered that the motion to substitute local sponsor and counsel is granted. Attorney Stephen Richards is now local sponsor and counsel. Attorney Richards must sign every document filed in this court. Reference it by exactly what it was. I suppose we'd have to go up to say which one is which. This is yet another one of the remands. So I guess she's probably doing them in order. So the first one was probably if it's for scientific testing, that must be for the bones. CD is the next one. Yep. Okay. You are hereby notified, and again, same people, except Kathleen Zellner is on this one as one of the people who are notified of the order. You are hereby notified that the court has entered the following order. So in the case of Wisconsin versus Avery, before Riley PJ, that must be the judge, the appellant Stephen A. Avery by counsel moves to supplement the record with a compact disc disclosed to the defendant for the first time on April 17th, 2018. And that's interesting, right? Because we found recently that we all know that the CD was in Tom Fassbender's personal possession, right, or for safekeeping. Additionally, we found out recently that he also has the recording of Dolores Avery made on the 9th, Billy, of November, when everybody got their DNA taken. Yeah. And Stephen got arrested. So why does he need to have that in his personal safekeeping? What is so important that she said that needs to be preserved in his personal possession? Just like this Veely Brady violation.
Filed yet?
One more time, Myron?
Was that FOIA filed yet for that?
I think our friend Carla was working on that. I'm not sure whether she's done it yet or not.
Okay.
Do you know, Justin?
I have not heard.
Okay. Avery alleges that the CD contains exculpatory material evidence and that the state's failure to disclose the CD earlier violates his due process rights to a fair trial under Brady versus Maryland. The state objects because the CD, was not part of the record before the circuit court when it was denied. When it denied Avery's Wisconsin Statute 974-6 post-conviction motion and his motions for reconsideration. Avery has filed the reply asserting that supplementation is appropriate because although the CD itself was not presented to the circuit court, the facts surrounding the suppression of the contents of the undisclosed CD to trial defense counsel are contained in the record through Avery's prior post-conviction motions and attachments thereto. Avery contends that we should add the CD to the record because the circuit court had all of the Brady issues before it, and the state should not be rewarded for having suppressed the CD until after the appellate record was completed. Avery's reply misses the point, which is that we are not a fact-finding court and cannot consider items not presented to the circuit court. Based on the assertion that Avery recently received previously withheld discovery or other new information, we retain jurisdiction but remand this case to enable Avery to file an appropriate supplemental post-conviction motion in the circuit court. Avery shall file any supplemental post-conviction motion within 30 days of the date of this order. The circuit court shall hold proceedings on the supplemental post-conviction motion and enter its written findings and conclusions deciding the supplemental post-conviction motion within 60 days after this motion is filed. In the event Avery remains aggrieved, the circuit court clerk shall retransmit the record, including any post-remand papers, according to the procedure. Appeal will continue. In addition to any pre-existing issues, the parties' appellate brief shall address any new issues arising from the circuit court's post-remand order deciding Avery's supplemental post-conviction motion. If Avery is afforded relief pursuant to his supplemental post-conviction motion, he may seek dismissal of the pending appeal. If the appeal is dismissed but the state is aggrieved, it may file a notice of appeal from the circuit court's order deciding any supplemental post-conviction motion entered pursuant to this remand. And that's a mouthful right there. Therefore, it is ordered the motion to supplement the record is denied. It is further ordered that this appeal is remanded forthwith to the circuit court to permit Stephen Avery to pursue a supplemental post-conviction motion in connection with Avery's receipt of previously withheld discovery or other new information. And the circuit court has basically said in that this is awfully fishy that this thing showed up so late, and he deserves the right to have it included as part of this motion. And oh, by the way, before we do that, Judge Angie, do you agree it was a Brady, which is automatically trigger a new trial? It is further ordered that any supplemental post-conviction motion shall be filed in the circuit court within 30 days. It is further ordered that the circuit court shall conduct any necessary proceedings to enter an order containing its findings and conclusion within 60 days after the supplemental post-conviction is filed. So they gave her a time limit, which was cool. I hope if they do this again, they give her another time limit. I'm sure she'll take it down to the last second. It is further ordered that if Avery intends to order a transcript of any post-remand hearing, he shall do so within 10 days after the circuit court enters its order deciding the supplemental post-conviction motion. Any such transcript shall be filed and served within 20 days after its request. Avery shall provide the court reporter with a copy of this order. It is further ordered that Avery shall file a statement on transcript within 15 days after the circuit court enters its post-remand order deciding the supplemental post-conviction motion. The statement on transcript shall reflect that a post-remand transcript has been ordered, or that such a transcript is not necessary for this appeal. It is further ordered that the circuit court clerk shall retransmit the record to this court within 20 days after the later of the entry of the circuit court order resolving the supplemental post-conviction motion or the filing of any post-remand hearing transcript, if ordered. The record shall include any papers filed pursuant to this remand. It is further ordered that the appellant shall file an appellant's opening brief presenting all grounds for relief within 40 days after the filing of this record. Boy, that was a lot of orders. I guess they order you around, but that was the CD. So I guess this one is the bones. Okay, so that starts the same people again. Richards instead of Fallon, Zellner, Judge Sukowitz, etc. You are hereby notified that the court has entered the following order. State of Wisconsin versus Avery, before Riley P.J. Stephen A. Avery, by counsel, appeals the circuit court's denial of his Wisconsin statute 974-06 post-conviction motions. He moves this court to stay the appeal and remand to the circuit court so that he may raise new claims premised on the recent discovery of a previously undisclosed police report dated September 20th, 2011, which, according to Avery's appellate counsel, reflects law enforcement's transfer of multiple suspected human bones from the Manitowoc County gravel pit to the Whiting Funeral Home for return to Teresa Hallbach's family. Avery alleges that the state violated its statutory duty to preserve evidence, see Wisconsin Statute 968.205, and that the state's actions violated Avery's constitutional due process rights as a Youngblood violation. The state has filed an objection to Avery's remand motion on the grounds that it constitutes a new and separate action, which is unrelated to the orders Avery presently appeals, is unnecessary to the resolution of his pending appeal, and would result in unnecessary delay in litigation. The state's objection points out that this, in effect, is Avery's third remand request. The state objection does not address the merits of Avery's claimed statutory constitutional violation and has not responded to Avery's supplemental filings alleging the possible destruction of evidentiary items, which it appears the parties previously agreed to preserve. Right, but we know how Judge Angie ruled on all these.
Yeah.
The state suggests that the appeal is languishing and that if Avery wishes to pursue new claims outside the scope of Wisconsin Statute 974-06, post-conviction orders presently on appeal, he could dismiss the pending appeal or wait until its conclusion to file his new claims. As to the former, Avery understandably disagrees. Understandably means, yeah, we understand. It makes sense why he's doing this. Aware that dismissing this appeal will preclude review of underlying orders entered to date. So yeah, if he dismisses it, the current things are gone. So it doesn't make any sense to do that. And the appellate court understands that, but the state apparently does not. Having considered the party submissions, we determined that the best course of action is to grant Avery's motion to stay the appeal and to remand under Wisconsin Statute 808-075 for action upon specific issues. As the state's response acknowledges, the decision to remand is left to this court's discretion. Though we are not required to remand, we determine that this procedure strikes an appropriate balance given the specific circumstances of this case. Due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than positioning the claims to be procedurally barred in a future proceeding. For these reasons, we desire a ruling on the merits so that all the claims to date can be considered in a single appeal. The briefing in this appeal has not commenced. There appears to be some potential overlap between the old and the new issues. Therefore, it is ordered that this appeal is remanded forthwith to the Circuit Court to permit Stephen A. Avery to pursue a supplemental post-conviction motion raising claims for relief in connection with the state's violation of Wisconsin Statute 968.205 and Youngblood versus Arizona. It is further ordered that any supplemental post-conviction motion shall be filed within 14 days. It is further ordered that the Circuit Court shall conduct any proceedings necessary to address the claims raised in that supplemental post-conviction motion and shall enter an order containing its findings and conclusions. We know what proceedings she held to be able to make that determination, don't we? Zero. It is further ordered that if a party intends to order a transcript of any post-remand hearing, the party shall do so within 10 days after the Circuit Court enters its order deciding the supplemental post-conviction motion. The ordering party shall file a statement on transcript. Any such transcript shall be filed and served within 30 days, and all that paperwork baloney. It is further ordered that the Circuit Court shall retransmit the record to this court within 20 days. I think more paperwork stuff. Nobody cares. It's further ordered that the appeal is stayed until the return of the record following demand. It is further ordered that the appellant shall file an appellant's opening brief presenting all grounds for relief within 40 days after return of the record. That's from Judge Reif, Sheila T. Reif. And that is the end. That was a mouthful. But I'd say that moving all the way back to the beginning, that Zellner really handed it to them. She went through her steps that she went through to vet the Sawinski affidavit. She actually we know now that she actually got the email from him on December, I think December 20th, she said, of 2020. And she had been working on vetting this information since then. That, of course, that December 2020 was after the current briefing, the current big briefing that we have was already done. And I guess after sufficient investigation and getting in contact with him and seeing his affidavit and assessing his credibility, is when she just decided to file this motion to stay the appeal and remand it back to the Circuit Court. So we'll see. I mean, to me, she went very deeply into seems like a lot of things that maybe she didn't necessarily need to, but she certainly presented the case in full.
I'm still taking this all in.
Yeah, I'm still taking it all in too. I think I think there's some things there that I'm a little uncomfortable with regarding some of the differences between the email that he sent to the Innocence Project in 2016 was it, yeah, and the affidavit. I can see how some things are clarified by discussion. There's a lot of things that are, overall it's still kind of the same. I think the fact that he is intending, if anything happens as a result of his affidavit with regard to the $100,000, he's like, if anything happens, give it all to the Hallbacks. I'm not interested in that money. Mm-hmm. I just want the right thing to happen. That's what people with integrity say. So frankly, that is an integrity booster to me.
Personal information is that scroll past quite findings. Amongst those findings were the previous automobiles listed on there.
So yes. Yes, the investigator Kirby did investigate the types of cars that he had before. Was that the question? Yeah. I don't think that's listed in this response.
Okay. Because I know we scrolled past that information pretty quickly because it's full of personal information, and I get what I was.
Yeah, I didn't have a lot of time before, so it may be there, but I didn't read it or see it.
Well, thank you, Jeff, for reading that, and I hope you guys enjoyed that. We have to get ready for a podcast in an hour and a half, so I'm going to cut this.
Your other podcast. I love it.
We'll see you later, y'all.
Okay, thank you.
Thanks, Jeff.